So understand a motion for reconsideration. You're saying there was a palpable error. There was a real problem here that the court completely blew it. So this is an attorney from Mandridge Law working for a big creditor who must have probably relied on ChatGPT. Even ChatGPT screwed it up. It was so embarrassing for an attorney to do that. It's so embarrassing. And then to double down and do it again, that hearing is going to be a lot of fun for me. Don't be afraid to point out the other side's baloney or buffoonery, or in this case, just really bad attorney. Both documents cite the wrong rule. So if you think for a second an attorney is better than you and went to law school, therefore you're going to lose, I got two things to say to you. Parker GPT, it's the AI defense lane that you need to be in. It'll do everything for you. A lot better than this guy, number two, who's an attorney and I assume went to law school and passed the bar. Hey, Brian Parker here with another interesting video. This one's called, What is a Motion for Reconsideration? Okay, it isn't boring, I assure you. This is kind of interesting. And the way I present this today, I will show you a member of the bar working for a major creditor who made not just one, but two critical errors. They're really the same thing that he made again for this major client, and I can see that there must have been a ChatGPT influence in what that major client did in filing response briefs and then a motion for reconsideration. So attached to my video will be a response to a motion for consideration created by me, it'll be in Word, and we'll embed it in Parker GPT. A motion for reconsideration that I filed, so you can see how it's broken down. Again, I think this one is Michigan, but they follow the same dynamics, just follow your state rule. A motion for reconsideration checklist. You know I love my checklists, and I try to get those checklists done for you. I think we're gonna do a video. My next video is gonna be a video checklist on the checklist that Parker GPT has embedded at Killdebt.com. They are just the way to start doing whatever it is you need to do, and it's all embedded in Parker GPT, which is the AI response to what debt collectors are doing today. They're depending on AI, you need me. Show notes, 10 pages here, but let's go. I did a recent video on JP Morgan. This particular firm, I'll tell you, it's Mandridge Law. My experience is that they don't stay on top of things. So with that in mind, when I represent a client, I know the buttons to push and when they're going to show and not show. And in this case, I sought a deposition and they didn't respond. You always do this. You do an email and go, hey, could you give me 3 dates when your client's available? Always blow me off. And I know it. So I'm used to it and I can set them up. So then I file my notice of deposition. I want it on this particular day. I don't remember what it was. It doesn't matter really. So I heard again, nothing from Mandridge Law. And then suddenly they emailed me to say, hey, we're filing a motion to quash your deposition. So they don't communicate with me, don't work on a certain day so that we both can work and cooperate together. And then when I have to go file my own notice of deposition without them, they file a motion to quash. So I received this email. There's certain ways to stop a deposition, either by objecting or doing what most good attorneys do, which is say, hey, Parker, I can't make it that date. We've worked together in the past. How about these 3 dates? They file a motion to quash. However, they never did. They told me they did. You saw the email. But I talked to the court and I go, hey, when's the motion for quashing my deposition? Like, what are you talking about? I go, the attorney specifically told me he's filed a motion to quash with you. And the court's like, there's nothing in the file. So he made it up. So then I filed a motion to compel saying, hey, they just made up and stopped my deposition going forward. There's only 2 ways to do that, none of which they did. They fabricated a motion that didn't exist. So I filed a motion to compel the deposition, get their witness in, sent them the notice both by email and by mail. And with this firm, you have to send them 3 things if they require 1. They just ignore you all the way through. So they did not show it, the motion to compel. The court said, well, all right, the record looks pretty good. You obviously notified them, et cetera, and I did. And the court granted me $1,000 for having to go through all this charade. As soon as I think it was kind of pissed off about the fabricated motion. I just handed the same email I just showed you. I send that to the court. So then the court ordered that they get their custodian of records in front of me within 10 days and also pay me $1,000, of which they did right away. No, they didn't. What did they do? Well, what have they done so far? They blew me off. So this is attorneys, more than one attorney over at Mandaridge Law Firm, just blowing their responsibilities off and continued to do it. And then well beyond the 10 days that the court had given them to do everything, I started peppering them. I'm like, hey, you've got to do this. I'm not going to do anything. Just follow what the court's order. Just blew me off. So then I filed a motion to default them. And that's the next step. When someone won't cooperate in discovery, you go motion and compel for discovery. And if then the court orders something, you're involving the court. Now they're going to be pissed because you don't blow the court off. And they ignored the court's order. How does a court rule? It rules by its order. So if you ever hear a court say, okay, you can do this, do this, don't take it as gospel. The court speaks through its orders, not just on the bench. So make sure whatever it is that came down that you heard the court say, get it in an order. And this I did, and presented them with notice. And eventually, about a month and a half later, they finally pay me the $1,000, way past the 10 days, after I filed a motion to default them and dismiss the case. This time they showed up, and this is their claim, and I will show you this. Let me put this up, their response to defendant's motion for default. Now suddenly they're awake. And this is very common, by the way. As soon as you get the attorney's feet to the fire, he suddenly notices that you're filing things. So you zoom. That's the motion they filed, and I'll just read the good stuff. They're claiming I filed a motion to compel deposition and award sanctions. I did, and served it upon plaintiff without notice of hearing. So they received it, but they didn't receive a notice of hearing. They're claiming. This is the company, by the way, that made up a fabricated motion to quash. So one of us is a fabricator, let's put it that way. I wonder who it is. So now it says plaintiff counsel, that's the Mandaridge Law Firm, admits defendant's counsel emailed a copy of the motion with a notice of hearing. So they know what date the motion's going through. They didn't show. However, they say email service is not valid means of service under MCR 2.109. So with COVID, nobody wanted to meet anybody, and there's this rule at Michigan and it's everywhere else, MCR 2.107 C4, that says the parties can agree to do everything by email. And I can tell you, living through COVID, no one even bothered agreeing. They just emailed each other. And to this day, now that everything is clear, nobody follows the rule per se, meaning we don't first write to the court and go, we the two sides have stipulated. I deal with the same people all day long, and we just email. In fact, as I recall, remember I showed you that email? The guy sent me an email notice saying there's a motion to quash. So now he's saying, yes, I admit I got the motion by email, but under 2.109C, that's not good service. I've been doing this, look at all this gray hair, it's all gray. That's from reading and writing for 32 years. I know stuff. Okay, 2.109 is not, having lived through COVID, which you should know the rules to stay home and do your stuff, I knew 2.109C was not the rule allowing parties. And I'm like, this is an attorney. How, I don't get this. So I pointed to the court at the hearing for the motion to dismiss. Hey, I sent him overnight. I sent him emails. I sent him carrier pigeon. I did everything to notify them. And he admits in this brief that he received notice, but because it wasn't under the proper rules, he had a right to blow the hearing up. So the case should not be dismissed. And the court said, get the hell out of here and dismissed the case. It's a very rare thing, a creditor case. I got the case dismissed because he blew both the rules off and then the big man. And so I also pointed to the court that the main issue is that JPM is claiming they received service, but because we didn't follow 2.109C, we had no right to send email that they had relied upon. So let me just show you what their main argument was in their previous brief. Shazam. Plaintiff counsel admits that defendant's counsel emailed a copy of the motion with a notice of hearing, yet plaintiff counsel now says, however, email service is not a valid service under 2.109C. The problem was, as I told the court and as I told Mandridge in my response, 2.109C does not cover email service between attorneys. So here's what 2.10C, the real rule, says. Shazam. And that's 2.10C, 07C, service and filing of pleadings and other documents. Email, text message, alert. You can do all of that if the, quote, the parties agree to alternate electronic service amongst themselves, which happened without even any writing during COVID. You're like, I'm not leaving the house. And we just freely emailed each other. Well, that carried on. 2.109 controls, let me put it up for you, security for costs. 2.109, on a motion of a party against whom a claim has been asserted in a civil action, if it appears reasonable and proper, the court may order the opposing party to file with the clerk a bond. It's got nothing to do with email service between the parties, right? So plaintiff's motion then was based upon the fact that we hadn't followed 2.109, which did not apply to any of this. So I couldn't figure out why you start to doubt yourself. You go, wait a minute, does 2.9 really control this whole thing? So I went to, and I had a sneaking suspicion they were using ChatGPT. So I went to ChatGPT, Shazam, and I said, tell me about 2.109, here's their motion, right? And it goes, oh yeah, that means you can only email between parties, service by email, electronic means, quoting 2.109. So I said to ChatGPT, hey, that's 2.107. What about 2.109? ChatGPT said, you know what, you're absolutely right, Brian. My prior answer was quoting and analyzing 2.107, not 2.109. So I advised the court that they got this wrong in their motion, and at the hearing for the motion to dismiss, the court granted my motion, as I said, based on that reasoning. So they've just let it go, right? They realized the error of their ways. No, they followed what's called a motion for reconsideration. So let's put that up there for you. That's their motion for reconsideration. And essentially in Michigan, and it's the same all the way around, Michigan is a unique twist. It's one of the few states that said, when you file a motion for reconsideration, you're saying to judge, you just ruled this way, you're complete error. Michigan's unique in that it doesn't allow the other side. So I won, they file a motion for reconsideration. I'm not allowed to argue against what they say. It's just between them and the court. And the court says, you know, you're right, I screwed up. Unlikely, but I'm not allowed to respond. However, a judge can say, you know what, I'd like to hear from the other side. And indeed, that's what happened here. So understand a motion for reconsideration. You're saying there was a palpable error. There was a real problem here that the court completely blew it, right? So that's what they say in their, no, they didn't. Here's what they put in their motion. Shazam. Plaintiffs received a mailing without a notice of hearing from defendant. Plaintiff counsel admits that defendant counsel emailed a copy of the motion with a notice of hearing. However, email service is not a valid means of service under 2.109C. Do you see what they did? They doubled down on the wrong rule. That's an attorney for a major creditor relying on something other than the rules. What's he relying upon? Is it ChatGPT? You be the judge. But in order for you to have a motion reconsideration, you have to say to the court, hey, you screwed up and here's why. They relied on the wrong rule again after the court ruled against them when they brought it. And I pointed out, that's the wrong rule. It's 2.107. They went in and filed the same motion relying on 2.109. You can't make this up. This is under the, you can't make this up. How does an attorney behave like this? This is what bothers me. I really work hard. I am not the smartest guy, but what I do is I make up for hard work. It's grinding and it's driving me nuts. But I don't let stuff go out like this. How does an attorney do that knowing the other side told them you got the wrong rule, right? So let's be clear, 2.109 requires a party to post a bond to cover the defendant's potential costs. I'm the defendant. They wouldn't file 2.109, it doesn't apply here. 2.107 covers the service and filing of pleadings and other papers between attorneys. 2.109 requires a party plaintiff to post a bond. Why would they say to the court, we need to file a bond? It doesn't make any sense. There's no appeal or anything. So even before they got dismissed. So this is an attorney from Mandridge Law working for a big creditor who must have probably relied on ChatGPT. Even ChatGPT screwed it up. That's the only way I can see that he was screwed up. But to be notified and then do it again, you've got to show something different in your motion for reconsideration. Something like a new law that was passed or something where the court really got it wrong. In motions for reconsideration, it's probably a 5% chance that the court is gonna reconsider what they already ruled upon. So here's what a motion for reconsideration is. A motion for reconsideration is a request asking the judge who made a ruling to reconsider and change their decision. It's the most common type of post-trial motion used when you believe the judge did not properly consider certain evidence. So the Mandridge Law firm is saying, could you reconsider the wrong rule that we cited wrongly again? Could you see that there should have been a bond? There's no requirement for a bond to be filed. A motion for reconsideration, and this is key, are not opportunities for presentation of the same facts or arguments available when the prior motion was considered. There's a lot of motion for reconsiderations that focus on new law or new facts, but they use the same brief for their motion for reconsideration without even taking any effort to even fix 2.109, which I literally served them and get, hey, you shouldn't do this. Didn't think they'd be filing a motion for reconsideration. It was so embarrassing for an attorney to do that. It's so embarrassing. And then to double down and do it again, that hearing is going to be a lot of fun for me. So when you file that motion for reconsideration, don't be afraid to point out the other side's baloney or buffoonery, or in this case, just really bad attorneying. Is that a word? I don't know, lawyering? But I'll show you the first thing I said to them in my motion. Again, as you always know, whatever I file, I like to front load. I want an ADHD or overworked court to get a real flavor of what I'm talking about from the get-go. Remember, the court doesn't have the bandwidth to keep reading and going all the way. It's like watching one of my videos. So you gotta throw it up front, right? So here's the standard review, speaking of snooze alert. The standard review for a motion for reconsideration, at least in Michigan, is the following, and it's basically the same everywhere. A palpable error which the court and the parties have been misled. So they did mislead, they misled, we didn't. They misled the wrong law. You can't make this up. And correcting that error will result in a different disposition of the case. The error was theirs, it's clear. So in order to win, the palpable error is defined as the following, Shazam. It's obvious and clear, not requiring extensive analysis and debate. Well, in this case, there's no analysis or debate. They've relied upon the wrong rule. It's plain to see, it's readily apparent from the record. Yeah, it's plain to see that they screwed up. Unmistakable, not a matter of interpretation or judgment. It is unmistakable that they made a mistake. So it's a heavy burden that is placed upon JPM, but they're relitigating the same facts that already show professional malfeasance supported by documented fabrications and legal negligence in failing to meet this burden, I argue. So essentially, they are recycling the same legal arguments, case citations, factual timeline, and statutory provisions that are just wrong in both their original motion and the one they want, original response, and the motion for reconsideration. They've got the wrong court role, the same case law, same sanction rule. Both filings emphasize that plaintiff sends an overnight check to satisfy the $1,000 sanction. They blew that up for over a month, by the way, so they missed the 10-day rule. They thought paying meant they can get out of it. It's like a burglar breaking in to a house, getting caught, but just before he got caught, he went and fixed what he broke and returned everything. And he says, well, how can I be guilty? I fixed everything and I paid for it. Well, no, the crime was already committed. Both documents cite the wrong rule. So if you think for a second an attorney is better than you and went to law school, therefore you're going to lose, I got two things to say to you. Parker GPT, it's the AI defense lane that you need to be in. It'll do everything for you. A lot better than this guy, number two, who's an attorney and I assume went to law school and passed the bar. I've never seen anything like this twice. The first time mistakes happen. This country is a country of second chances. They doubled down on the wrong rule. It's going to be a lot of fun at this hearing. I'll let you know what happened. But do not think anything less of yourself because you're not represented by an attorney. Parker GPT, Killdebt.com is your partner through all this. And I'll have attached to the website in this video a response to a motion for reconsideration, a motion for reconsideration I filed, a motion for reconsideration checklist if you feel inclined to do this, and my show notes, which are a lot of work. But you know what? You gotta put a lot of work into something to be successful. See Mandridge Law Group, no one ever said that. So good luck, do hard work and it pays off, and I hope my hard work pays off for you. Thank you.